All right, good evening, everyone. I'm Fleur Kingham. I'm the chair of the Queensland Law Reform Commission. I'm welcoming you to the launch of the Commission's review of Section 315 A, choking, suffocation and strangulation, and that's a section of the Queensland Criminal Code. We also call this review the Non-Fatal Strangulation Review. I want to begin by respectfully acknowledging the traditional custodians of the lands on which we are hosting this event from, which is Meanjin, Brisbane, and that's the Jagera and the Turrbal people. I also acknowledge the traditional custodians of various lands on which our online panellists and our audience gather from, and I pay my respect to and I honour their elders past and present. And I want to acknowledge and welcome all First Nations people who are attending tonight's event. I want to thank the Centre of Excellence for the Elimination of Violence Against Women, who have partnered with us in delivering this webinar, and to thank the University of Melbourne for their technical support. I also want to thank the Red Rose Foundation and those with lived experience who have contributed to a very important video that we will be showing shortly. Given the nature of this review, some of the content that we will be discussing tonight may be confronting or distressing. And of course, you're free to leave the webinar at any time. But should you require support, please see the list of available services that are displayed in the chat panel. We encourage you to be interactive in this webinar. So if you have a question for the panel, or if there's a comment that you would like to make, please submit it during the Q&A function. I want to assure you that all questions and comments will be anonymous. Other viewers will not be able to see your questions. We have people here who are moderating the Q&A, and they will select questions to ask the panellists at appropriate points during and following the panel discussion. Now, you will not see her, but Jodie O'Leary, who is the director of the Queensland Law Reform Commission, who is leading this review, will choose some questions where we have time to include them in our Q&A, but be assured that we will look closely at all questions and comments that are made by any of you during the session tonight. If your Q&A function is not working on your link, you can also use the chat function to communicate with Melbourne University for any technical support. As you can see, we've got a few bells and whistles we're trying to deal with this webinar. Now, as you entered the webinar, you would have seen a QR code to engage in a survey through a program called Menti. And we'll display that information again at the conclusion of the panel discussion. And I'd encourage you to take the time either immediately after the webinar or sometime before the 1st of December to enter that Menti session and answer the very limited questions that we have posed in it. Again, all responses in the Menti survey are anonymous, and only the moderators at QLRC will be able to see your responses. But we're really interested in hearing from everyone who has registered to attend this webinar as to what you consider to be the key issues for the review to consider. We're in very early days, we're just launching the review, and we're wanting to hear from as many of those who have either lived experience or expertise in assisting those who have lived experience with this offence. And you also would have noted that this webinar will be recorded, and we'll publish that in due course on the Queensland Law Reform Commission website. So if you do have to leave the webinar at any time, or if your link is lost for any reason, there will be a recording available. So let me turn to explaining this review. In September this year, the former Attorney General gave the Commission terms of reference to investigate to review and investigate the operation of this section, section 315, capital A of the Queensland Criminal Code. The terms of reference require the Commission to consider if, firstly, the terms chokes, suffocates and strangles should be defined, and if so, how. Secondly, to consider whether the requirement that the choking, suffocation or strangulation, which I will refer to as non-fatal strangulation, must occur without the other person's consent, whether that requirement should be removed or amended. Thirdly, to consider whether the offence should apply to conduct that is not committed between those in a domestic relationship or is not associated domestic violence under the Domestic and Family Violence Protection Act of 2012. That is, should it extend beyond that domestic context as it's defined by that Act. Fourthly, to consider if the current maximum penalty of 7 years imprisonment reflects the gravity of the conduct. And finally, if the offence should be able to be finalised in the magistrates, or for those of you who are outside Queensland, a lower court rather than one of the higher courts, in Queensland, most often the district court. This webinar coincides with the publication of the background paper, our first background paper, and a number of supporting resources for the review, and they are available now on the Queensland Law Reform Commission website. The link was available, a link to those documents is available via a QR code, which you saw on the opening screen, and we'll show that code again at the end of this webinar. But in any case, if you just go to our website, you will find the material. You'll see from our background paper that the Commission wants to encourage inclusive, respectful consultation in the review. That's critical for us in developing our recommendations. After we've done some further research, we anticipate releasing a consultation paper which calls for formal submissions around the middle of next year, and will then produce a final report and make any recommendations to the Attorney-General by the 1st of December next year. So the aim of this webinar is to start the conversation and to encourage as many people as we can to engage with us during this review. After we play our video, we will move towards a conversation with our panellists. And we're very fortunate to be joined by 4 people who both individually and collectively have a great depth of expertise and experience across the areas of criminal law, domestic and family violence law, practice and research. And I want to introduce them to you now before I play the video. Firstly, Professor Heather Douglas, who is online, is a leading expert on the legal response to domestic and family violence with expertise in criminal law and procedure. She was the co-chief investigator of the Australian Research Council's discovery project called the Non-Fatal Strangulation Offence as a Response to Domestic Violence. And you'll see in the background paper we have referred to some of that work. She's also the chief investigator of the Centre of Excellence for the Elimination of Violence Against Women. Dr. Leah Sharman, who's here with me, researches social and emotional health and decision-making among victim survivors of domestic and family violence. She also worked on the Non-Fatal Strangulation Offence as a Response to Domestic Violence project. Thelma Schwartz is the Principal Legal Officer of the Queensland Indigenous Family Violence Legal Service. Thelma has practiced for more than 25 years across the Northern Territory and Queensland and has worked extensively with and for Aboriginal and Torres Strait Islander peoples. And her efforts in this space were recently honoured by the Queensland Law Society with the Dame Quentin Bryce Domestic Violence Prevention Advocate Award. And I take this opportunity to formally congratulate Thelma on that well-earned award. And finally, Glen Cranny, who's here with me, is an experienced criminal law practitioner. Doyle's Guide has listed him as a preeminent criminal defence lawyer in both Queensland and Australia for more than a decade. And we're very lucky to have him as a part-time commissioner of the Queensland Law Reform Commission, while he is also director at Gilshannon and Luton. At the Commission, we recognise the important contribution of those with lived experience of the areas of law that we are reviewing to inform our recommendations. And as such, we wanted to start today's discussion with a video of a conversation between victim survivors and Betty Taylor, who may be known to many of you. Betty is an Australian community advocate and campaigns for domestic violence prevention. She founded the Red Rose Foundation, which aims to eliminate domestic and family violence-related deaths by monitoring outcomes and making recommendations across Australia to ensure responses to domestic violence protect potential victims and are as safe as possible. Betty was named a member of the Order of Australia for her significant service to the community through domestic violence initiatives. Her efforts and advocacy have a direct link to the establishment of the Domestic Violence Review Board here in Queensland and the introduction in Queensland of this offence that we are reviewing. With that introduction, now we'll play the video.
Talking to you about your experience of strangulation, and if it went to the criminal court, what was the process and outcomes? If you didn't, some of the barriers that you came across that it didn't go.
Okay, yeah. So about my case, the place won't proceed at the very beginning of everything. So it didn't really go to criminal court. So I think the reason the place didn't proceed, one thing is they think my ex-partner's statement was quite different from my statement, because my partner described in his statement that I attacked him first, which is like my the scratches I caused to his arm when I was trying to fight for my life. I tried to push his arm back, and it left the scratches on his arm, and that was used by him to provide it to the police. I think that is the one main reason they won't proceed, because they just told me like my husband's statement was quite different from what I said. And another thing is, another main reason is, although I told them that I have red marks and I told them what happened when they attend, and I don't think they seem to believe me at the first interview they had with me. And although they captured the red marks and they recorded my statement, but they don't believe me at the first time. Yes. Yeah, and I think I wasn't being listened to, because like the whole conversation, they keep cut me off.
Yeah. Even though you had the red mark.
Yeah, and I think if I can find like another reason is maybe it's because they were not looking at like the whole background story of the relationship or the marriage, because there are a lot of like other controlling behaviors that exist before the physical violence occurred.
Ariana, did yours proceed to court?
Yes, mine's in the process at the moment of going to district court. I was told that they would be all charges together in the magistrate's court, and then in September they told me that the strangulation charge would be going up to district court, but I haven't heard anything further from that.
Okay, so it's gone through the committal hearing and now it's gone up to district court, and we can talk through the Red Rose further about that.
Yeah.
Thank you. Kathy.
Well, mine did make it through to court, although it was a very long and protracted process. was actually nearly 3 years by the time we actually got to the district court. The incident happened in January of 2020, and the trial was in October of 2022. Throughout the process, it was a nightmare of hearings, adjournments, no end of manipulations by his legal team. So we eventually got there, but unfortunately, he was found not guilty at trial after a 4-day trial. And to be honest, to this day, I still don't really understand how or why that happened, although I have had some insight to it, and a lot of it has to do with the lack of prosecution having available experts to give testimony. There was, his side were able to bring in a lot of evidence about my previous mental health history, things that were completely irrelevant to where I was at the time of the assault and as to what transpired at the time of the assault. So their ability to bring in my past history, all of those things tainted the view for jurors, as far as I'm concerned, who have no expert knowledge in any of the things surrounding strangulation and the control and things that go along with that. So I made 6 points basically that I think are really relevant in terms of processing or changes I'd like to see through the system. And that was the length of time it takes to get from the initial charges to the court process. It was just so traumatizing for me. The other thing is the lack of expert witnesses to help support the state case. You have to remember that you're the only witness for the prosecution. You don't have your own lawyers. You don't have your own experts. It's a very traumatic thing. So I think it would be beneficial to be able to have, for the prosecution to be able to have those sort of experts to counter arguments that obviously the other side bring in. The other thing that is really important to me, and looking back very significant to me, is on the night of the assault, I was asked if I would like to go to hospital. Obviously, I was severely traumatized and in shock. And apparently, I don't remember saying this, but apparently I told them no. So from my point of view, I think it should become mandatory that at a thing, when somebody is accused of strangulation or says they've been strangled, it should be mandatory to go to hospital, because I had no concept of the medical implications of, I'd been strangled until I was unconscious, and I had no idea of what the future implications for that could mean. So I think that's very, very relevant, that some sort of mandatory hospital visit for the victim is taken in for evidence as well. I did go to the hospital a few days later and got myself seen too. The other thing that was very significant for me and traumatized me quite a lot is the fact that as a witness for the state, I was put on the stand. I was hammered for basically the 4 days. My ex never uttered a word and was never put on the stand, which meant that the prosecution could not test any of his evidence. So if their legal representation chooses not to put them on the stand, the prosecution cannot interview them and take to task their version of the story. So to me, that was very, very significant and quite traumatizing, to be honest. His character and his past history was in no way tested or challenged. Mine was hauled through the coals significantly, and things that were completely irrelevant from, 20 or more years ago were brought into play to taint the view of jurors who had no better idea. So I think that's a very significant thing.
Thank you, Kathy. We just come back if we've got time, but I want to hear from Ariana and Jenny about what would you like to change? What could have been different?
Yeah, I think one thing I probably need to mention again, which I really agree with, is if we report to the police about strangulation, they should have mandatory hospital visit. Because at the time on the day I was strangled, as I mentioned, because they weren't listening to me and they don't believe me, although I mentioned that to them, but they didn't take me to a hospital. And I was, yeah, still like the same. I was in shock and I don't have time or energy to think about like going to the hospital. But that later contributes to maybe a lack of evidence in there. And also I wasn't like, I don't have like medical care like instantly for the incident. So I think maybe if there is something they can do a bit more, one thing is to take good care of the victims. And another thing is to maybe to better define like the meaning of strangulation.
Ariane, the last comment before we wind up, but what would you change?
The main problem that I've encountered is no one explains the court process. Even right from the start of him being interviewed, no one explained to me that he would front court the next day, what that meant for me, if he was to get bail or released. No one explained any of the process of adjournments, mentions, everything along the way. Even now, 8 months in, no one explains anything except they tell me the next court date.
That's it.
So there's no explanation of anything, and except I have to go myself to try and get an explanation as to why it's taking so long.
Yes, and Kathy and other women that have been through that process can certainly relate to that. Our allocated time, unfortunately, I think is up. Thank you all so much. But I really think going forward into next year with these reforms, there is a place for you to have your say, your story. They're valid stories. If we're going to change the system, you are the ones that know how, why, and when it should be changed.
I want to acknowledge Betty Taylor for putting that video together for us, and to thank Ariane, Jenny and Kathy for their generosity in sharing their stories with us. You'll see that as we start our discussion with the panellists that there are some themes that came through from their stories that we'll pick up on. And throughout the review, we will continue to reach out to women with lived experience of this offence. But it is now time to move to the panel discussion. I've already introduced our panellists to you. Just a reminder to feel free to ask questions throughout the discussion through the Q&A function. But I want to pick up, I think it was Jenny who talked about the definitions for this offence. So I think that's a good place for us to start. And I'll open this discussion by asking you, Heather, if you have a view about this question about the definition of the offence and whether it should be defined by reference to the act, the grabbing of the throat, the squeezing of the neck, or the smothering, or the consequence of that act, such as interference of breath or blood flow.
I think it needs to be both. I think it needs to be both the action and the effect. I think that people often do activities where the neck is touched. It's pressure on the neck or the smothering or stopping the breathing that's the problem here as well. It's both of those two things are important. When there was research done in the US in terms of why this offence was brought in, it was very focused on strangulation and putting pressure on the neck. demonstrating that people held another person's life in their hands potentially. So that kind of level of control in relation to strangulation. So I think that both of those things, pressure on the neck and the effect of that hindering the breath or blood flow, is important. I don't think that we want to open this offence up too widely. We already have, I think, a fairly significant criminalisation issue of over-criminalisation in some contexts, so we need to be very careful about that. And I think having those two elements of that definition are useful in ensuring that the right people are prosecuted in relation to this offence.
Thank you for that, Heather. I know, Thelma, in our discussion of this topic that I think you used the term terrorising, the terrorising nature of the act. And I wonder if you've got a perspective that you can share on this question of definition of the conduct that is criminalised.
No, thank you for that question. I too look at the consequence of the act. The act is of particular importance to me when I look at viewing the relationship as a whole, which has seen a significant impact now into the definition of domestic relationships and taking into a context the impact of coercively controlling behaviours. And I think it's really important to note that people who use violence in coercively controlling relationships will use an arsenal of tactics to control, manipulate and terrorise their victims. And I don't want to get to a point where we're so transfixed by the consequence of that act that it becomes a battle within the criminal trial process of two opposing medical experts around the amount of pressure and the intent behind it. And I think for me, I try and get balance, especially when I'm looking and I'm hearing the stories from my clients and the context within which they've been exposed to terrorising acts, both physical and non-physical, over the duration of that relationship.
Thank you for that, Thelma. You will be aware that recently Section 315A of the Code, this offence, was amended to include these words. A person is taken to choke, suffocate or strangle another person if that person applies pressure to the other person's neck that completely or partially restricts the other person's respiration, blood circulation or both. And I suppose given what you've just said then, Thelma, about the way in which a trial might proceed, a question I have is whether there are potential unintended consequences from defining these terms in this way, and whether this could lead to dueling experts in a criminal trial. And I might flick to you, Glen, on that, whether you have had an experience or a view of the way in which medical experts might be drawn into prosecution of these sorts of offences.
I've certainly seen plenty of reported examples of where there has been that competition, or at least evidence given by experts about issues about the level of restriction and so on. But I think we've come a long way definitionally in respect of this offence since when it was introduced 8 years ago. A review of the literature shows there's really been two principal points of contention in respect of the definitions from the outset, and that is whether it included both the restriction of air and blood, and secondly, whether it involved a partial restriction or required a full restriction or occlusion of air or blood. Those things have been largely resolved by both some case law, but then the recent definition, which you've just mentioned, Fleur. Whether there's more work to do in respect of those definitions is something the Commission's looking at and something that's discussed in the background paper that's just been released. But we've certainly come a long way at least addressing those couple of threshold issues that did cause concern in the early years of this offence. And I think that hopefully also reduces particularly the emphasis upon partial restriction being sufficient on that need for medical evidence. And it may well be that complainant's evidence is regarded as sufficient in the majority of cases.
All right, we've got a question that I'll ask Jodie to read out.
It's actually more of a comment about the definition potentially missing positional asphyxia if defined too distinctly. And the comment was the definition of pressure means that expert will be tested to the amount of pressure used. And the evidence behind the pressure required to occlude carotids is extremely weak and based off a very old French and German literature. That's the comment.
Right.
Could I mention something there?
Yeah, please,
Fleur?
Heather. Yeah.
And something that we've introduced in Victoria are some guiding principles that really highlight the question of the level of pressure shouldn't be the focus. So there's a guiding principle at the beginning of the legislation which basically says that essentially the issue is that putting any level of pressure on a victim to hinder their breathing or restrict their breathing in any way, that's the thing that asserts the physical dominance. So it's not really whether you cause an injury, or it's simply that feeling of pressure and that feeling of not being able to breathe fully normally. So that might help in Queensland as well, bringing guiding principles that point to that issue.
So that goes beyond the way in which it's defined in the Act itself, but perhaps is interpretive material that can be used within the trial of an offence.
It's something that, for example, a judge could direct the jury about.
Yeah, yeah. Leah, do you want to add anything on this topic?
I think pretty much everything has been covered. I think if anything else, I think I will be picked up later on.
Okay,
Yeah.
great. All right. Well, look, let's move on then to the second topic, which is this domestic context. And that is that at the moment in Queensland, the offence only applies if the conduct occurs in a domestic context, and the definitions are related to our Domestic and Family Violence Act. And I guess I've got two topics I'd like to explore under that heading. The first is, assuming for the moment that that domestic context is retained, is it currently too narrowly or indeed too broadly defined, that intimate relationship? I might throw to you, Leah, on that topic.
I don't know. I mean, I think within the domestic context, I think that it's probably perfectly fine. I'm not sure. I mean, I know that there are issues, other issues in terms of not being able to, I mean, usually we've heard stories from survivors about their children also experiencing strangulation, and that not being addressed, and that's being seen as some part of a family court dispute as well, and that being an issue. But yeah, those are sort of tricky things to kind of get around.
And Thelma, is it something that you've encountered in your practice, that the definition of domestic context itself is too narrow so that prosecutions are not taking place, even though it is occurring within that family context?
This is probably where you might have a bit of a mismatch between how we see family relationship defined, or family violence defined as set out within the Domestic and Family Violence Protection Act, as opposed to the narrower focus on domestic relationship, focusing in on intimate partner relationships. What we know in the broader context of family violence is that family violence within Aboriginal and Torres Strait Islander peoples and communities will involve the broader community. It might start off with, a couple, but it'll then spread across into the broader family and kin connection. So very much picking up on what Leah has said there. What if the terror is not only the directing of the assault, whether physical or non, towards, let's say in this case, mum, but it is then taking it out on the child, because then, how do you then protect that child or the other person if they're not caught within the definition of domestic context? So I would probably be looking at aligning the definitions to meet what we are seeing, that broader family connection as captured under the Domestic and Family Violence Protection Act to catch broader family kin relationships where it's used as a tactic of power, control and domination and terror.
Thank you, Thelma. Heather, with your review of this sort of offence in other jurisdictions, is there anything that we can take from the way in which the scope of the offence is defined elsewhere?
Look, I mean, originally this offence was really brought in as a result of what we know about intimate partner violence and the future risk of strangulation. But increasingly we know that strangulation, you know, if someone's strangled to the point of losing their breath or seeing stars, that's actually really dangerous and causes terrible neurological damage potentially for anyone who does it to anyone. So the curious thing about limiting it to domestic and family violence contexts or domestic and family contexts is that it says in all these other contexts it's okay. So we're sort of setting up this binary between family context, not okay, other contexts, well, that's a different story. And I guess we really have to think about whether it is such a different story. Do we want to limit it to that context where we're really focused on future risk? Or are we saying, don't strangle anyone anytime, it's a really dangerous thing to do? And I guess that's a distinction that we need to think about here.
Well, that really prefaces the second aspect of this topic, that do we take it outside that family context? And what I take from Thelma is that she considers there's a cultural issue with the way in which we're defining domestic and family violence that isn't capturing the full impact of this violence perhaps in Aboriginal and Torres Strait Islander communities and perhaps in other communities where there is a broader view taken of a more expansive concept of family than is captured in our fairly narrow definitions in that Act. But you've taken that next step of, well, what would it mean were we to broaden it to apply outside a domestic relationship? And Leah, I think earlier when we were talking about definitions before we started this webinar, you drew attention to the danger of having a limited definition that focused on the act rather than the consequence if it were an offence that applied more broadly.
Yeah, I mean, I guess I'm more broadly worried about the unintended consequences of loosely defining it without having some element of consequence involved, especially as we know that strangulation is occurring in a lot of different contexts, especially sexual contexts, as a form of violence, but also as something that is consented to in as best people seemingly to be consenting. And so with our research recently finding that quite a substantial number, approximately half-ish maybe, are thinking of people under 30 are engaging in strangulation or pressure on the neck or hands around the neck, whether it's very light pressure or quite firm. And that's something that is happening across the country, and so that's quite concerning. So I'm thinking a loose definition, given that it's kind of just being engaged in quite frequently, and in consenting areas might not be useful.
Glen, did you want to add anything on this topic?
There's no doubt that if it were broadened, it would be a major shift, given that the original impetus for the offence arose out of the context of domestic and family violence. I agree with Leah that I think the unintended consequences issue is going to loom large in terms of any look at reform in this area, if any is thought necessary. Obviously, and this touches upon consent issues as well, in terms of personal sexual activity. But beyond that, you've got sporting activity, security, policing, those sorts of things. So there's lots of different contexts that will need to be taken into account if there is to be any shift in the context of the way this offence is applied.
I recall reading, I'm not sure whether it was the United Kingdom or somewhere in Australia, where a broader based offence, so that did extend beyond the domestic context, had specific defences relating to things such as the acts of in a security context. Is there anything that you could draw to our attention, Heather, that relates to that a broader scope, but specific defences beyond perhaps consent, which we'll turn to in a moment?
Yeah, look, I think it's mixed around the country in Australia. Just in Australia, it's also mixed in other jurisdictions, but some jurisdictions like Victoria, I think Tasmania and a couple of others in Australia don't limit this offence to the domestic and family violence context. So, and I'm not aware that that has created many more prosecutions necessarily, or unintended effects. But certainly it's not unusual to have that. And I think I would want to challenge the idea that it's okay for law enforcement or sporting activities to actually be using headlocks or pressure on the neck. So I don't know that that's a good reason to allow this to happen. I think what Leah was saying before, though, what our worry, I suppose, perhaps we would share it, is that if there's a whole lot of young people doing this, do we risk over-criminalising those young people? And that would be a real concern. But I wouldn't want to give the message to law enforcement or sporting activities that headlocks are okay. I gave judicial education to a bunch of judges in Tasmania, and they were talking about jiu-jitsu and how they were often unconscious in jiu-jitsu. And we just know now that that's not very good for you, you often end up with quite serious disability later in life, die younger and so on. So it's actually a real question we should be asking about how we think about this, and should we be saying there are places where this is okay, or should we be generally saying it's not, but there are some defences that we justify for various policy reasons. I don't know that security reasons are a good one. I could see police misuse of this and prison warden misuse of this. And I don't know that sporting is a good one either. This is a dilemma I'm facing in my own thinking, but certainly I think they're good questions to ask.
And it really raises the question of criminalisation of the conduct, because what we're discussing here is the risk. When we're talking about broadening it out, there's still, whether it occurs in a domestic context or not, there is a risk to the person who experiences this conduct. Is criminalisation the only way to deal with that risk?
Of course.
Particularly when you're dealing with such a high, apparently a high level of consensual
and
activity.
I do think that's a question to grapple with. What's the purpose of this? Is it the recognition of the high level of future risk for death and serious injury for those people, usually women in inter-partner relationships who've experienced strangulation? And that's, I think, originally where this came from. And should we be maintaining that limit? Obviously, we have assault. We do have other offences that could cover these non-consensual physical behaviours. So it's not like they're not necessarily criminalised anyway, but it's just a question, should we keep strangulation to this particular space, which we know is associated with future significant risk?
Yes, and that really picks up on Glen's comment earlier that to broaden it would be a significant change, because it did arise in the context of what we know about the risk of further violence where this occurs in an intimate relationship in the context of domestic and family violence. And that really brings me to the next topic that I wanted to probe with you, and that's this question of consent. If the focus of this offence is what happens within a domestic and family violence context, should we retain, should there be this requirement of an absence of consent, particularly what we know, given what we know about coercive relationships? I might start with you, Thelma, on that point.
I think consent is quite a tricky issue, and when I look at it through the lens of coercive control, you're talking about the complete domination of one person over another person in an intimate partner relationship. So how do you then elicit consent where you've got those elements of coercive control present? I mean, that's the whole idea of coercive control, looking at the relationship as a whole. So I really struggle with it when I look at the manner in which my clients have experienced relationships, the levels of controlling behaviours and acts, both physical and non, committed on them. And then when we're talking about non-fatal strangulation, and I see these discussions with my clients, particularly in the context of these acts are being committed in a bedroom. And then I'll have a client withdraw and then come back maybe a few days later, and then I'll get an indication of a level of sexual intimacy that's occurred without consent. You know, they're not wanting to do it, but where is the consent? You know, you're in a pretty controlled environment. So I think this is where I'm sitting on it and how uncomfortable it can be. And then when consent becomes an issue at trial, you know, especially in sexual assault matters, I see the rate of attrition for our clients just not wanting to go down that jury trial, particularly when I look at all of those things. And the fact, when I go back to Betty Taylor's video, you heard about the rigours of cross-examination, and rightfully so. I mean, a defendant has a right to know and test the evidence before them. It's a fundamental aspect of our rule of law. But I look at my victim survivors and where they're left, and how do I bring justice to these particular individuals?
Thelma, just picking up on that, I'm not sure, and maybe one of the panellists will be able to enlighten us as to whether consent is an issue that is raised in the prosecution of these offences. But I rather gather that question mark about consent could be a disincentive to a victim survivor taking a matter all the way through a prosecution.
It certainly can be.
Have I understood you correctly?
Yes, it certainly could be if this is the primary or main offence that is being pursued. There could be a plethora of other charges that are associated with non-fatal strangulation charge, noting that this particular offence must proceed on indictment. So these are some of the considerations that will be going through the mind of the victim survivor, and in terms of making up their mind, which way to go.
Just before I throw to the other panelists, we do have a question we might put in here. Jo?
Yes, so the question from the audience is, well, it's a statement about whether there are problems with consenting to your own potential self-harm without full prior health information about that. And the comment makes reference to a Red Wing experiment from the Second World War, where those who consented to being strangled found they couldn't withdraw consent when they actually wanted to.
Yeah,
Heather, I can see you wanting to come in on this, and I know you've done some research on this topic, so thank you.
Well, that exact study is something that Leah and I have looked at, and that was right. There was quite a strong group of people that were being strangled, and they were told that they could just gesture or ask the strangulation to stop, and it would stop. But the people doing the study found that many people didn't ask for the strangulation to stop. They developed this special neck cuff that they would tighten around the person's neck. They found that there was this kind of liminal space where people seemed to go into a paralysis and not say anything or do anything or gesture, even though afterwards they would say that they had wanted it to stop. So this notion of using safe words and being able to withdraw consent might be a good question. But what I wanted to say in response to Thelma too was this question of consent and how we define it in the legislation. It's not defined in the Queensland legislation. The presumption must be that it's the consent that we associate with assault, even though this is in a part of the Queensland Criminal Code that is amongst a whole lot of offences that you can't consent to, which opens up the question of, well, what does consent mean here? And I wonder whether one way to deal with this to some extent might be to define consent, because my understanding from the cases, and Leah and I interviewed and did focus groups with lots of survivor service groups, and they said that this was the context where they saw consent being raised around strangulation was in violent relationships. Women would tell them that they were experiencing violence and strangulation in their relationship, but then also having sex, and there was strangulation there too, and it was a bit more vague about whether there was consent there. But the workers would say, but there's coercive control in this relationship. How can there be consent anywhere to this strangulation? So it's the sexual conduct or contact where there was a claim of consent. So should it really be the sexual assault definition of consent associated with rape in Queensland, rather than the assault defence, which would open up questions for the court to consider coercive control and things that vitiate or take away consent, essentially. So that might be helpful. I'm not sure.
Thank you for that. Leah, did you want to add?
Heather pretty much said everything I wanted to say. But the only thing I wanted to add was maybe just at the end, we did interview service workers, and a group of them were men's behaviour change workers, and they do actually run, a couple of them have been running a section on strangulation. And when they asked them about strangulation, their response was, the men in these groups' response was, oh, do you mean during sex or outside? So they have an idea that they know that they can coerce consent, really, that is a consenting process. That's a separate process versus externally, just in everyday context.
Okay, important distinction there. Glen, do you want to add anything on this, John?
Just building on what Heather was saying, Queensland is obviously moving towards a stronger affirmative model of obtaining consent. But even so, in a truly coercively controlled relationship, that is just a horribly messy concept to try to distill what is genuine consent from what is coerced consent. There are all sorts of issues that I see with that issue, which are going to be tackled by the Commission in the course of its work. Another relevant feature is if a significant proportion of people are engaging in this sort of behaviour consensually in their private lives, it's a serious thing to prohibit or outlaw, criminalise conduct which at the moment is being practiced lawfully by a significant number of people. So there are serious issues at play here for sure.
And I suppose one of the difficulties that really Heather adverted to is that it's not clear what consent means in the context of this offence, and whether that stronger affirmative consent model that you talked about, Glen, would also apply in the prosecution of non-fatal strangulation. How is this issue of consent dealt with in other jurisdictions? Heather, I think you've done a review of some other states' legislation. Is there anything that we can learn from them?
Most other states do use the sort of classic assault definition. So the more serious the injury, there's public policy considerations, and unless it's a very serious injury like grievous bodily harm, you basically, you can consent up to that level, or you can consent to bodily harm, but there'll be policy considerations around it. So that sort of vague definition of consent that applies to assault. But in Victoria, we've recently introduced a strangulation offence, or two offences, two-step offences, and it is possible to consent to strangulation that takes place during sex if there's no injury to the person. I have issues with this as well, but the lower level offence is you can consent to that, and it's a sexual offence definition of consent that we're familiar with, affirmative consent definitions. And then there's a higher level of offence which there is an injury caused, which sends it up probably into the higher court, although there may be some discretion for the judges to hear it in the lower courts and the magistrates' court. But that higher level of offence which causes injury, where there's intention to cause injury, that cannot be consented to. The issue I have there is obviously, and I think this is common, a lot of women who experience strangulation have no injury, and it's difficult to actually connect any brain injury to that specific strangulation event, which is kind of what the law would require. So usually all you've got is red marks as your injury, which wouldn't be sufficient for an injury definition in Victoria. And a lot of the prosecutors and defence lawyers in Queensland say the red marks are really neither here nor there. They could just mean stress. So the distinction of offences based on injury is a bit problematic, but that's really where we've seen consent, an attempt to introduce consent in Australia is in Victoria. And that is such a new group of 2 offences that it's really difficult to say how that will play out. But that was an effort to accommodate what Leah and I have been talking about, and Glen, about young people who are engaging in this so readily. But obviously I have concerns with that as well.
I recall from some of the research that you and Leah have done about I suppose the difference between the perception of risk and safety that young people have and the reality. Leah, is that something that you would like to talk more about?
Yeah, I mean, generally people just don't have an understanding of the harms, and we really don't have a full understanding of what the harms are, because a lot of the research is quite new, and a lot of the strangulation research in the past has been conducted on people who have died. So we don't actually necessarily know the extent of those harms. We know that you can get, brain injury from being strangled during sex. There's been some recent research happen that if you were strangled during sex within the last couple of months, that you're likely to have slower reaction times, be slower to process things. But people just don't really have a good understanding even of just the most basic issues, apart from they could die if it goes on for too long, or if there's too much pressure. They know and understand that risk. But really anything in between is pretty much nothing. They don't have any idea about that. And that's more about education. And I don't know that criminalisation can really help with that process.
So as with other aspects of this review, there is a fundamental question for the Commission to be looking at, which is the scope of the criminalisation of conduct. We have another question on this topic before we move off it.
We do. We have a couple of questions that are on this point, exactly about the fact that non-fatal strangulation injuries can't be seen externally, and that CT scans can see more damage, and wondering why the legal profession perhaps is not as updated on the medical research into non-fatal strangulation. Another question about, is it easier to detect and use those MRIs, CT scans, etc., and use those as a matter of course in evidence?
Well, this is Leah knows all about this.
I don't know if I know all about it, but MRIs are a really good option. There are some other options that are kind of coming out that are easier to use, easier to access. But those things are all well and good if somebody's really immediate. I mean, we see it through in the videos, has resources, has access, is able to get away from their abuser and get to, a doctor or a hospital. Those are the issues, really, that it's not always immediate and that people are not always able to access medical care. They don't know that they need to access medical care until a week, 2 weeks, 3 months down the line. And they're still experiencing difficulties with their vision, their memory, their voice. I definitely using that medical evidence is so helpful, but relying on it is also a problem as well. Yeah.
Glen, did you want to comment on this?
Experience in homicide cases shows that this idea of injury is a really problematic marker of this sort of offence. There's regularly we see homicide cases where there's very little injury, and obviously smothering is perhaps the most obvious example. Where you talk to pathologists, forensic pathologists, who will say it's almost a symptomless crime. So this notion, Heather was saying she had some concerns about that definition which has been introduced in Victoria, and I can see why, because I see real problems with tying this too closely to the concept of injury.
Can I just say one thing though, and to pick up what the women who spoke at the beginning of the webinar was saying, I think this is a lot of the advocacy that Leah and I have been trying to promote in our research, as you say, Fleur, it's not all about criminal law reform. Some of it is about making sure police do get these women to see medical health and help seeking, because even if there's not a criminal offence, get them in early, they may be able to deal with some of the sometimes terrible injuries that can result weeks and months down the track if they get a proper checkup. So I think there are policy considerations around police procedure and so on that are really important to consider here as well.
Thanks. I see that there are a number of comments and questions coming through on this topic. Again, I'll just say that we will be looking at everything that has been contributed by any of you who are on this webinar. But we have got another question or a comment that Jodie wants to insert at this point.
I just wanted to recognise there's some contributions from people with lived experience in the comments, who are talking about brain damage and epilepsy that they have from historic strangulation and extreme head trauma, and they weren't given that medical treatment at the time. So reiterating really what Heather was saying.
Yeah, and linking as Heather observed to the observation by Kathy in the video, and the strong support from the others of the need for medical attention. And of course that raises, as it does with so much of our law, the differences between resources available to people in the city and those in more rural and remote locations, which is something beyond the criminal law, but it's the context in which this offence is occurring. I'd like us to move on to the final sort of topic I've identified for the Q&A, which is prosecutorial issues, but really it's talking about the investigation of this offence, the gathering of evidence, how people are treated in that process in terms of medical attention. There were other points raised from the women who shared their stories with us about explanation of the court process, etc. But so panellists, please feel free to chip in on any aspect of investigation and prosecution of this offence. But could we start with this question of the trends, as in the successful prosecution trends? And I'm focusing on this because one impetus for this review commencing is a report from the Queensland Audit Office, which identified a successful prosecution rate of 50%. And when I looked at that, my first question was, how does that relate to other offences in a domestic and family violence context? Is this offence out of the range of the way in which other domestic and family violence offences are prosecuted? And I wondered whether any of the panellists are able to share information about that.
We did some research on this as well, and looked at the prosecutions in Queensland and compared it to prosecutions of family violence and gender-based violence around the world, really, looked at all the empirical research, and it comes out at about 50%. So that's pretty right on, that we see domestic and family violence cases being successful in about 50% of cases. And that's for a whole lot of reasons. Retraction is common, but the longer matters hang around, the more likely retraction is. So the longer it takes to resolve things, the more likely the retraction is. Usually the more serious the charge, the less likely the retraction, because the better the evidence gathered. So, for example, physical assaults and domestic violence, which leave bruises and wounds, have better success rates than simple assaults, for example, which is probably obvious. And so people are more likely to withdraw when the evidence isn't as good, and prosecutors are less likely to follow through when the evidence isn't as good. So strangulation, in spite of being a very serious offence, does fall out like assaults do because of this evidence problem, partly because women retract because the evidence is insufficient. So the reliance of the court will be on them, and their credibility essentially will be the thing that's in issue. So it is pretty even if we look at domestic and family violence offences overall, but it's perhaps a little bit higher than we would have expected comparing it to more serious offences that, you know, serious injury offences, bodily harm offences.
Well, there's a lot in that comment there, Heather, but there were two themes I'll draw out. One is the nature of the evidence, and perhaps the because of the nature of the offence and the act, the lack of the physical evidence means you're looking in a prosecution much more closely at the credibility of the complainant in that process.
I think that came through in some of the victim survivors' points at the beginning.
It was certainly a key theme from Kathy's story, wasn't it?
Yeah.
Yeah, and the other theme is the seriousness of the offence, and I'll come back to the and to what level it is prosecuted in the courts, and I'd come back to that. But
I think it also the delay, just to put the delay there as well. The longer the delay, obviously, these guys are going to be working on the relatives and friends and her to get her to pull out of the prosecution. So the more time he's got to do that, the better. Well, the worse, depending on how you look at it.
Yeah, I understand. Thelma, I'd like to draw you in at this point and ask you, is there anything that came out of that contribution by Heather that you want to discuss, or are there other aspects of investigation and prosecution that you think the Commission needs to be aware of in this review?
Thank you. I think there's a bit of a white elephant in the room here, and I'm going back to calling it out in the findings of the Commission of Inquiry into police responses to domestic and family violence in Queensland, and the 78 recommendations made and the findings by the Commissioner of systemic sexism, misogyny and racism within the Queensland Police Service. So when we are looking at particularly responses to Aboriginal and Torres Strait Islander victims who finally have the courage to report acts of violence, including this particular act, what we know from that particular report, coupled with Women's Safety Justice Task Force reports, is that they are going to be either over-policed or under-policed. And, you know, these are some serious issues here relating to when an Aboriginal and Torres Strait Islander woman wishes to make a complaint. And the engagements that we're seeing with Aboriginal and Torres Strait Islander women in relation to domestic and family violence incidences have indicated a high rate of misidentification of Aboriginal and Torres Strait Islander women as the primary aggressor. So I have some real concerns around investigative techniques and the ability to draw out and take evidence in a culturally appropriate manner, particularly if we're not going to see a follow-through with an embedding of those 78 recommendations made by the Commission of Inquiry to better inform and drive police responses, not only to Aboriginal and Torres Strait Islander victim survivors, but to any victim survivor, particularly those who are more prone to the impacts of domestic and family violence. And we see that level of vulnerability reflected and defined in the principles of the Domestic and Family Violence Protection Act. So this concerns me. You know, before I even get to what's going on within the actual successful prosecution of this matter. Now, if it's going through the Magistrates Court, it'll go through the committal handover or hand up. Sorry, I'm using the old language back from my old criminal law days. So we're waiting on 6 months before an indictment's presented in the District Court, where this matter will penultimately be determined. I absolutely agree. In that period, this whole process, there is going to be significant pressure placed on that complainant. Now, if this is a complainant who doesn't have access to a dedicated victim liaison officer, and we know from the evidence given by the Director of Public Prosecutions at the Senate inquiry into murdered and missing Indigenous women, there is only one Aboriginal and Torres Strait Islander victim liaison officer in Queensland. how do you then successfully walk hand in hand with a navigator to assist you understanding what the process is, where the potential for delay is, what is happening when bail applications are made? You become invisible to it. And I can understand why victim survivors are saying, this is too hard. I've got too much pressure in my community. I'm copying it from his family, my family. I can't deal with this. And they walk away. So I'm going to put that in, coming out from the other reports that we've seen with a specific Queensland focus around what may or may not influence successful prosecutions and police engagement.
So we've got those reports that the Commission can draw on in relation to that investigation process. And there's also the police responses report, I suppose, that is a fairly recent report that the Commission can turn to for recommendations for dealing with that aspect of the prosecution of this offence.
That's correct.
Yeah, yeah. So it's there are a lot of reports that have been done that we can draw on, aren't there?
There certainly are, and they're independent reports which have had some significant findings and shifting more positively in recognising victim survivors. And, you know, the space for victim survivors within the criminal justice system, and it is quite a difficult space for victim survivors to navigate with respect. It's about her without her. She's not even a party to the proceedings. And I think that, you know, from where I've been around Queensland, that is consistent. You know, I know that we've got a new victims commissioner, which was one of the recommendations from report 2 of the Women's Safety Justice Task Force reports that's now in place. And hopefully we'll see some real improvements with victim engagement and police and the DPP in working better with victims, in keeping them informed and helping them navigate the complexity of the criminal justice system.
Thank you, Thelma. Leah, would you like to comment on either anything that's been said by Heather or Thelma, or comment on any other aspect of investigation and prosecution, including delay?
All of everything that everyone has said so far, I agree with. But yeah, the delays are huge, and it's just, even if there isn't any pressure, there's so much confusion. We've heard from the stories at the start in the video, but you know, we've heard so many stories from so many people about just how confusing it is, and we end up relying so much on the DV support services that are available to basically do all of the hard yards, do all of the work to be informing women, finding out when the next court date is, finding out if they're on bail now, if their abuser has gotten bail and they don't know that they're out in the community. They just don't receive really any information. And it's just so demoralizing when you have to wait so long with no information, no understanding of what is going to happen. And then potentially, you know, 2 years down the line, they don't end up with a conviction, or it's just time served and then they're out again straight away. And so it just feels like such a waste of time and energy. So I think, I mean, I don't know that there's any where to go from that. That is a real significant frustration.
Leah, I want to pick up, you added something I think really important in that discussion of delay, which is what is happening to a person who is in custody charged with this offence. Because if they're on remand, my understanding, and Glen will be able to pick me up on this if I'm not correct, but my understanding is that somebody who is on remand will not have access to any rehabilitation programs because they've not yet been convicted of the offence. So if it's just time served, then they will be released without having been connected to any program.
Yep.
Yeah.
Yeah, that's absolutely correct.
Yeah. And one way of dealing with delay could well be to skip that indictment process and allow the matter to be dealt with in a summary way at the magistrates' court or the local court level. do you have any, I suppose, Glen, can you identify what would be the issues we would need to be considering as a commission were we to go down that path? That's one of the ideas we've been asked to look at in our terms of reference. Should it be able to be finalised in the Magistrates' Court?
In my practice, I act both for those charged with this offence, but also those victims of the offence. And I think this represents one of those rare instances where I suspect that both sides of the fence would welcome the opportunity for these things to be resolved quicker. There's no doubt that delay is enormously impactful upon the complainant, victim survivor, but also on the accused person. So I think there would be a strong measure of support for allowing the prospect of these things to be dealt with summarily. The research conducted by the Sentencing Council suggests that the average sentence for this sort of offence is, well, it's almost inevitably in prison, with a head sentence in the order of 2.5 years. So under the current Queensland regime, there's no obvious reason why many cases can't be dealt with summarily by magistrates. That would speed up the process enormously for all concerned, and I think there's a lot to recommend that. The issue about delay, particularly if the accused is in custody awaiting trial, is, as we've recognised, there's no access to education and rehabilitation. Oftentimes the research would suggest that the complainant has very mixed feelings about the accused person being incarcerated. They might be dependent upon that person. They might want to maintain a relationship with that person. So there's a lot of complex relational issues associated with all this as well. So there's much to consider.
Something that might be worth considering too is if there is a discretion to get it into the Magistrates' Court, which I think would be potentially worth considering, that it gets into the Magistrates' Court when there's a plea of guilty. That would encourage and incentivise a plea of guilty as well, I think, for many offenders, because they probably want to get it over with usually and get properly sentenced. Offenders don't like hanging around in remand either. It's a really pretty torturous set of conditions. So they would probably prefer in general to be sentenced more quickly. So that might help on a range of levels with saving some victim survivors or people who've experienced strangulation from giving evidence and having their credibility tested in this really horrible way in the higher courts, and it might also encourage greater pleas of guilty. So that might be something to consider if it's to be thought of as a discretionary point into the Magistrates' Court. And
Fleur, in that regard, I might add that is becoming quite well accepted in Queensland law now, that there are a range of offences, frauds, assaults, all sorts of things where there is the ability, the election rests with the defendant to plead summarily, but only to plead summarily, and thereby get it over and done with much more quickly for the benefit of all. But if they do want to contest it, then the indictable process follows. So that's not a stranger to our current system.
But leaves the election with the defendant rather than with the complainant.
That's the case with the majority of those instances at the moment.
Heather, we do have another question I think that Jody would like to bring in, but I want to come back to you about the court hierarchy and how this offence is dealt with in other states, whether it is able to be dealt with at a local or magistrates court level in other states.
In most other states it can be, but if you want to go to the other question first,
All right, I will come back to that because I want to understand how it works. Jody?
It's just a very brief reiteration of Glen's point. This is a legal practitioner from regional Queensland who noted that people who have pled guilty to this type of offence often are serving 9 to 12 months on remand, but they haven't participated in a single domestic violence or anger management course while held in custody. So just reiterating that there's this issue of lack of access to rehabilitation, and comments that was something that was raised in the Northern Territory coroner's report that was spoken about yesterday, about making courses available to people who deny the offence but have been convicted.
That would be ideal.
Yeah. So Heather, can I just come back to you on this question of how it works in the summary prosecution in other states? Is it at the election of the defendant, or is there some scope for the prosecution too?
Well, in other contexts, it can be generally heard in the magistrate's court. So the lower level offence in the Victorian context can be heard in the magistrate's court. There's a limit, obviously, on the penalty that can be applied because it's heard there. So it may be that the magistrate thinks it's too serious and needs to send it up to the higher court to get access to the higher level penalties. So, for example, in some cases, you've got a 7-year penalty. And so in the magistrate's court, we can only have a maximum of 3 years. But if that magistrate decides that that's just not enough for this particular offender, they've done this before or whatever it is, that they might send it up to the higher court. So that's generally how it's working. It's working on the magistrate's discretion to actually send it to the higher court.
Okay, thank you for that. And that really taps into the final question that I wanted to pose before we start to wrap up, and that is the one of the questions in the terms of reference is whether the maximum penalty of 7 years is an appropriate reflection of the seriousness of the offence. And I wonder whether that's something that Thelma or Heather or Leah that you would like to comment on. I won't ask Glen to comment because that's one of the questions he'll be grappling with as we do the review. How does it compare with the maximum penalties in other states, for example?
A lot of other states go up to 10 years, but there is an intention to injure with the strangulation. So, I mean, you could create a step offence in that sense, that in those rare situations where you can demonstrate a recklessness or an intention to injure and the person is injured, that could be associated with a higher penalty, and other offences that don't reach that threshold could go into the lower level offence, I suppose. I mean, the reality in Queensland is that I don't think any, if at all, I'm not sure, I'm not 100% sure, but I don't think any offences have got over 5 years out of the 7 in strangulation cases. Yeah.
So rare.
So rare. And there are obviously other offences that are 14 years and so on, grievous bodily harm, etc., that might be charged in some of these cases too. So there are options that get a higher penalty if that seems necessary. There also wouldn't be a problem, I think, with having a higher penalty, opening up a higher penalty for magistrates, but also allowing it to be heard in the lower court.
Yeah.
So that might be a compromise position, which would still let all of these offences that are generally being seen to receive that lower penalty, but seeing those really serious strangulations where someone is effectively, it looks like an attempted murder, but we cannot prove the intent, maybe. You know, you want the higher penalty. But I don't see that the offence itself in Queensland is nudging at that higher level of the sentence in most cases.
Thelma, I think earlier you indicated that you'd like to contribute to this topic.
I think it's such a rich topic, and there's so many angles and views to be expressed in this one. And when I look at victim survivors, look, I absolutely agree with having the ability for this matter to be summarily disposed of where it's appropriate to do so, unless the magistrate has a real concern that there is a higher penalty and it must proceed by way of indictment. And I think that really then gives a level of agency to victim survivors, particularly where a defendant says, you know, I choose to plead guilty to this offence. I mean, they are then getting the benefit of an early plea of guilty being noted, and it's determined. What concerns me, as we've rightfully had a discussion about, is that downtime in remand. You're sitting there, you don't have access to therapeutic care, you don't have access to behavioural change models to really understand the gravitas of your offending. Because a lot of my clients say to me, no matter where I am, I just want him to stop. I want him to stop. And this is difficult when they want to maintain that relationship. Now, you know of all of these elements that are going on, but she keeps saying to you, I want him to stop. There are children. He's the primary bread earner here. How do I get him to realise that what he's doing to me is unhealthy? It is potentially lethal and fatal. And then there are children present watching that behaviour and modelling on it. So I then look at if there is bail refused, you've got declarable pre-sentence custody. That time spent in custody is rightfully taken into account on the application of the sentence. So what are they going to do when they come out, particularly if they've served the actual time? Do we then need to start considering an element of community corrections orders, which was raised by the Women's Safety Justice Task Force, as well as the Queensland Sentencing Advisory Commission and the Queensland Productivity Commission's 2019 report on imprisonment and recidivism? Are there other ways that we continue to engage with people who use this type of behaviours and conduct in that family setting to really get through that the behaviour, what you're doing is fundamentally wrong on so many levels, so many levels. Yes, there's a criminal law response, but there is a human being accountability response that we need to take into account here. Because even if you deal with someone in a criminal justice setting for one complainant, what's then going to stop them from doing it with other victim survivors if that relationship they're in and they've then received a criminal law sentence comes to an end? So I look at bigger pieces. So that's me. I'll just hush now.
Thank you. Thank you, Thelma. There is a lot in not only what you've said, but all of the panellists have said tonight, and it's been a really insightful and important conversation to start our work on this review. But I'm going to have to draw it to a close because we've reached the end of our time. I want to thank each of the panellists for your time, both in preparing to take part in this conversation and your thoughtful contributions. You may well be called upon again during the course of this review. I also want to thank those of you who have participated in the webinar, who have either listened quietly and the many members of the audience who have sent in comments and questions, and I can assure you we will treat them with seriousness. I'm particularly pleased that there are victim survivors who have shared some of their experiences. And I want to reiterate that the Commission will be engaging as widely as we can in an appropriate way with people who have experience of this conduct that has been criminalised. So in closing, there are just a couple of things that I have to say. A reminder again for any of you, if this discussion has raised concerns for you and you need assistance, there are support services that are noted in the chat function, and they'll also be listed on our closing screen. Again, on our closing screen, an ad for our Menti survey. It's really very short, but it does give us the opportunity to hear from those of you who either haven't sent in questions or comments during the webinar, or who have got more that you would like to say. There is another QR code which takes you to our website, and also how to subscribe to the review. So if you subscribe to the review, you give us an email address, we will keep you informed throughout the review. As soon as anything's published, you'll be made aware of it. And it's also the way in which you can communicate with us during the review. And I encourage you to maintain your involvement with us. At any time, if you have ideas, suggestions, evidence you want to point us to, or feedback you'd like to give about our work, please use the email address, which I think will be on the closing screen. If you scan the QR code, if not, just go to our website, you will find it. We have got a bespoke email address for this review, which is qlrc-nfs@justice.qld.gov.au. And please let us know. Please have a look at our background paper and let us know if you think we have missed any key issues. I know we've only skated across the surface of some really complex topics that the Commission will be grappling with during this review. And again, I thank all those who participated, including the women whose stories were videotaped, for their generosity in sharing their information and expertise. So thank you.